Thank you, Your Honor, for allowing my voluminous argument this morning. And
Well, you get 20 minutes later.
to my case, I appreciate it. Pinellas County, together with the Water District, have engaged in a non-uniform billing practice that is incongruent with the legal requirements of the U.S. Constitution in Article 1, Section 8.
Okay, I want to stop you before you get too far into your argument, because I'm going to be candid with you. I've reviewed your submissions to the court, and I'm not really clear on what your grievance is. Is this about you got a property tax bill and you think it's too high? Or you don't think there should be property taxes at all? I'm trying to get at what actually is your grievance concretely, and what were you thinking that the court could do to address your grievance specifically? That would help me if you could focus on that for me.
The non-ad valorem assessment as underpositioned on the county ad valorem property tax lien is a non-ad valorem, unduly elected body of government that intends on levying against the civilian population to the
So
tune of...
your position is that the Pinellas County Taxing Authority tax collector has no authority to impose taxes, or
It's the form of taxation. One is the lien, as we're accustomed to. Let's say, for instance, Dave loses his job and
So
can't
you
pay
say, I'm really trying to understand, in a more concrete fashion, what your argument is. Are you saying there just should be no property tax?
A lien and a levy are two different animals. One's a monster and the other one's a teddy bear. A levy, under the circumstances, this is a third-party levy that's being underpositioned on the county ad valorem property tax. Now,
What's the third party? The water district?
would be the water
And they're
district.
not a party to this action.
I feel as though our water issues, based on the 14th Amendment, have been influenced, contrived, a lot of capricious and misuse of water
Can you tell me what water issues you're referring to?
in developing such reclaimed water availability fees, which in a sense is a hostage taking of my supply and rate from my county utility to support a third-party bond contrivance on that availability fee. That's a whole separate issue. It does relate to the non-ad valorem assessment levy.
Well, let me just go back to another question that I asked initially that I don't think you answered. What relief were you seeking from the court?
In order to justify such taxation, our water district is an appointed body of government. They need to be elected, duly elected, as our commissioners are at the county.
But how do you think the court can, grant you that relief?
Well, apparently, based on Florida Constitution, Article 12, Section 15, the court may restrict or withdraw ad valorem taxing powers. Such taxing powers as a unduly elected body of government in a form of a levy is inappropriate taxation when I'm on my ad valorem billing, I'm accustomed to a county property tax lien. This levy goes straight into the equity of our homes. This levy...
Are you talking about a levy for water?
The water district levy, in a sense, is the beginning of a whole separate political standing that we have yet to see. Based on Pinellas County Resolution 95-286, Section 4, C-2, stating absolute bill of sale and release of county lien, the county's already been sold to the Water District
What?
in a fee simple 30-year title transfer. Over the next 30 years on our ad valorem, we're going to see line items that support the county to be one by one positioned under district control. So we won't see Pinellas County Schools up there as an ad valorem charge. We'll see district schools, which once were Pinellas County, but have now been assumed as district control. The whole political structure is shape-shifting from its fortnighted statesmanship into a politically laundered watershed operation. Over the next 30 years, this fee simple.
Okay, well, I think one of the issues that the trial court struggled with, and frankly, I'm struggling with as well, is how is you brought this action against the tax collector. Okay, how is the tax collector the proper party to challenge what you're challenging?
I, as a taxpayer on my ad valorem, am to challenge who on my ad valorem's taxes? That would be the tax collector.
Well, the tax collector is just the tax collector. And it sounds like your grievance is really with Pinellas County and the Water District.
Which I brought my argument before both the Pinellas County and the Water District at every meeting for the last 14 years.
Okay, but I understand that could be very frustrating, that you've done that and that you haven't gotten whatever relief it is that you're seeking. But that doesn't make the tax collector, it doesn't default then to the tax collector. In other words, what could the tax collector do to relieve the situation that you contend is unlawful?
A uniform billing practice is required by law. The levy is an unwarranted charge. I feel as though that levy needs to be repealed and replaced and maintained as a property.
Who would do that? Who has the authority to do that?
The court system does, based on Article 12, Section 15 of the Florida State Constitution.
Okay. Go ahead.
I feel as though this incongruent ad valorem, non-ad valorem, unduly elected, not a property tax lien, based on statute 197.3632, I believe, the non-ad valorem levy is not based on the millage rate. So now we have a non-ad valorem, not based on the millage rate, unduly elected body of government intending on levying upon the residential population. At the same time, the county's already sold out to the Water District, and there's that quid pro quo agreement again, where the county wants to shapeshift itself from its fortnighted statesmanship into a politically laundered watershed jurisdiction under the 14th Amendment. Then the due process clause of taking liberty, property, and life is actually legal under the 14th Amendment and the birthing of water jurisdictions. I see an insurrection taking place with this non-ad valorem, not based on millage charge. And I believe that we need to correct such inappropriate.
Well, I hear that you're aggrieved, but I think the difficulty the trial court had, one of the difficulties, and the difficulty that personally I'm having is understanding how the property tax collector is the proper entity to seek relief against. And I'm not sure you've really answered that.
Your Honor, who do I pay? if I get a bill from the phone company, I have to pay the phone company. And if I get an inappropriate charge on my phone bill, I take the phone company to court. I take the tax collector to court when he taxes me, and I feel as though
Well, the
the
tax collector just collects it. I mean, it seems to me that your issue is bigger than that. You have an issue about Pinellas County and the water district entering into an agreement that results in, I guess, ad valorem tax on water. Is that what you're complaining about?
the assessment is a surface, it's claimed as a surface water assessment. It's based on impervious layers on your property, your driveway, your pool deck, or whatever, and they charge you
So
accordingly.
there's an assessment based on how much impervious area you have on your property? Is that?
That assessment,
Okay.
again, is not an ad valorem charge. It's not a county charge. It's not based on the millage. It's a levy. It's not a property tax lien. Nothing fits. It's as though, let's say I go to the store and I want to buy a stick of bubble gum, and the lady says, well, you can't buy a stick of bubble gum unless you buy a jar of pepper. And if I'm going to have a government that says, we're going to tax you on bubble gum, and even though you don't want pepper, we're going to throw in a pepper charge. I feel as though you didn't start out that way. Now all of a sudden you're ad hocing, you're contriving, you're invoking charges that aren't warranted. Same thing goes with the reclaimed water availability fee. My county utility sells water wholesale on a supply and rate basis. Then we have a third-party facility that sells you the privilege of opportunity to access the availability thereof fee for the reclaimed water. And I said, you just took out my supply and rate. I don't want to buy your pepper because my supply and rate to my vital water access now has a toll charge to it. You taxed my water supply in light of a bond yield based on statute 15311. Now, when we get back to the county ad valorem charge, they're doing the same thing. They're capriciously compacting charges that are unwarranted, and they've been built up based on legislative wayward behaviors, mostly from apathy and neglect and misuse of our water supply in order to contrive these charges and feel justified in levying such charges upon the residents. That type of legislative behavior needs to be denounced.
Well, again, you just said the word, legislative behavior, so that's not the tax collector. Your grievance is with legislative behavior.
On
And I
my
guess
tax.
you said you've been before the water authority, you've been before Pinellas County, and you haven't gotten any relief, so your default is tax collector? Would that be an accurate
As
way
I'm
to
forced
look at this?
to pay my property tax. I believe last year they stopped collecting property tax at the Pinellas County building in Clearwater. And now we're forced to pay our property tax at an off-site, which is I believe it's down by where you register for your driver's license off US 19 somewhere. But the tax collector, in my mind, deserves to be charged because he's the one I'm paying.
Okay, if you wanted to save some time for rebuttal, sir, you have 5 minutes left.
Thank you.
Okay, all right, thank you.
May it please the court, Jason Esther on behalf of the Pinellas County Tax Collector Charles Thomas. You are correct. The tax collector aggregates assessments from taxing authorities. Pinellas County is a taxing authority. Southwest Water Management District is a taxing authority. The tax collector knows nothing about these assessments other than that these are valid taxing authorities that can certify a roll to the tax collector for collection. The tax collector is an appropriate defendant in a suit regarding taxes or assessments, but merely in a ministerial duty to collect the taxes and distribute taxes as the court orders, refund taxes as the court orders. That is all the tax collector knows about the validity of these assessments. Pinellas County and the Southwest Water Management District, neither of them were parties to this suit in the circuit court.
So, in other words, it's not your ministerial duties that are being challenged. It's really the response, what's being challenged has to do with the taxing authorities.
That's my understanding.
And not, yeah, to the best that you can discern.
Yes,
It's not any exercise of your ministerial duties.
correct. If a court were to find that these two assessments were invalid, the tax collector would refund.
Right. You would
Those
be
months.
unnecessary. Refresh my memory, was the water district ever a party to this
No,
action? Okay.
well, except for, I believe that when it was transmitted from the circuit court to this court, they were added, some maybe by the clerk to the second district, I'm not sure.
I feel like I saw something about they were in at some point, but now they're not. or-
And then at some point, the Water Management District filed a motion to dismiss themselves because they were not a party to the underlying action, and it was granted.
So they never were.
Correct.
Okay. It's always just been against the tax collector.
That's correct.
Okay.
Are there any further questions?
No.
Okay.
Thank you.
Thank you.
Thank you. Appreciate it. Mr. Pettis?
Thank you, Your Honor. The levy is a district levy based on statute 373.0697. It's a district charge. They are a party to this.
Who is?
The Southwest Florida Water Management District is a party to
But
this.
you know, they're not actually a party. You may have wanted to make them a party, but that did not occur.
Based on statute law, the non-ad valorem levy is a district charge.
No, I understand that, but you didn't make the district a party to this litigation, to this lawsuit.
I attempted to. I'm not a lawyer. I'm just a regular guy.
Now, I understand that, but anyone that is trying to bring an action against, there are rules to follow, and the clerks, yeah, I mean, you were able to make the tax collector a party.
I attempted to make the district party. Being, as I see at their meetings, last meeting, they were going over their budget hearing, and they spoke primarily of the ad valorem charge. And I balked, stating that it's not an ad valorem charge that they're charging. It's on the ad valorem bill, but it's a non-ad valorem charge. It's on the ad valorem lien, but it's not a lien, it's a levy. Kind of like driving the county lien into a water district levy, and it's a levy gonna go dry. I mean, I don't want to sit up here and sing songs, but this is an issue that seems to be on not just my purview, but there are other people that take note of the slight touches and changes upon the county billing practice that could subject us 20, 30, 40 years down the road to unforthrightful and unsovereign forms of taxation. And that non-ad valorem levy is the taxation that I fear.
I guess what the trial court determined and what it seems like to me is you have this grievance, but you have brought your lawsuit against the wrong entity to to have the court address your grievance. It's not really, at this juncture, the reason the trial court dismissed your case and you haven't really been able to satisfy me as to how the tax collector, without having the taxing authorities also part of the litigation, is a proper party to proceed in this lawsuit. So I'm gonna give you one more shot at telling me why you haven't included the water district or Pinellas County in this.
I had attempted on bringing both of them in. The water district somehow persuaded the court that they were not privy to the charge, and I disagree with that. They are in absolute part of this process. And I feel as though that if anyone's playing games with the court system, it would be the county and it would be the district working and colluding with one another.
Okay. All right, thank you, sir.
Thank you.
You can vote. All right, next up this morning, we have Renhack versus Walmart